Hello, everyone. My name is Mihoko Sumida, a professor of civil law at the Hitotsubashi University in Tokyo, Japan, and leading legal innovation research from Japanese side. Legal innovation research is an exploration for justice in the super smart society in the future. And today, I will talk about our recent study, risk and best practices for using generative AI in judicial decision, together with Yuya Ishihara, who is an AI engineer and researcher. The use of generative AI for various language-related tasks, such as text generation and summarization, become more widespread. Issues such as risk and challenges of hallucination and bias have been raised, and legal regulation are being discussed. On the other hand, from the perspective of improving access to justice, there are also many calls for the benefit of speeding up and improving various aspects of judicial decisions. And there have been few opportunities to discuss ethical norms for the use of AI, including generative AI, in courts from a legal perspective, as in recent cases. Therefore, in this study, we will focus on the technical composition of the data used by these methods, such as the learning methods of large-scale language models, including generative AI and text generation, using external databases that utilize the retrieval augmented generation RAG technology and has attraction in recent years, with the aim of identifying any legal or ethical risk and issues. We will then consider possible solutions and desirable governance. However, the use case to be considered in this study will not be limited to those for which proof of concept research is underway in both the public and private sector, but will also include use cases that are discussed as possibility for the future. The study will consider implementation method based on current technological feasibility and discuss issues related to ethical aspect. When we focus on the conduct of judges in the courtroom, litigation proceedings in Japan generally progress through the following steps. First, arranging issues and evidence, fact findings, and legal analysis and reasoning, write the reason of the judgment, and write the main text of the judgment. And below, you will see the function that could potentially be applied using AI in the judicial decision-making. First, in arranging the issue, the point of issues are extracted from the allegation of the plaintiff and the defendant. Second, in fact-finding, draw inferences about the fact that can be determined from the submitted evidence. 3, in fact-finding, providing information that can substitute expert opinion. Number 4, in legal analysis and reasoning, it presents related law, precedent, and legal interpretation. Drafting various documents using the text generation capability of generative AI, which is the simplest and most general use case, including outside the code, will not be considered here, as it is not relevant to the purpose of considering governance related to decision-making using generative AI. In addition, there have been recent initiatives by private companies in relation to number 4. The function expected to be realized for 1, 2, and 3 were identified by Professor Wataru Murata, ex-judge, and now a professor at Juo University. At the finale event, which was held in last December of International Joint Research Project Legal System and Artificial Intelligence, which was held by the author. At the time of writing, it is expected that the realization of these functions will bring benefit, such as the speeding up of the dispute resolution and deepening of examination. But the full implementation of the digitization of case records, which is a prerequisite for those, is still 2 years away, and no information have obtained that a policy for a creation of such big data had been decided upon.
However, the following risks have been identified, including the current AI and generative AI technologies. First, hallucination. As is well known, sentences generated by LLM can be different from reality, and there is a risk that decisions will be made based on unreliable information. And second, bias. It has been pointed out that in addition to generative AI is subject to fairness biases due to factors such as biases in training data, and LLM is subject to social biases due to training data and also training methods. When judges, who are required to carry out their duties from fair impartial standpoint of view, use it as a tool of assistance in the decision making, so another consideration will be required to ensure that an unfair disadvantage is caused by before the parties are informed. So third, the black box. The inference processes of deep learning models is difficult for humans to understand. It is well known. And it is necessary to consider not only the reasoning processes, but also the transparency of training data and the reliability of its accuracy. And fourth, digital divide. So it is not particular for AI, but there is a risk that the digitization of litigation proceedings will make it more difficult for people who are not familiar with information technologies, because the right to access to justice is guaranteed by the Constitution in Japan and other countries, I believe. And the security. So usually LLMs and LLM services are utilized via cloud services. So there is a risk that could be compromised by factors such as internet accesses. And the next slide. So another risks. In addition, following issues have been also raised when considering the application to the judicial systems. So the first one, lack of training data and mediation or settlement cases. The training data available is basically limited to judgment documents. It has been pointed out that there is a risk of biases in learning, as around half of actual civil litigations end in the form of settlement or mediation. And second, difficulty in obtaining the case record information. So it is difficult to obtain information such as evidences and facts that were not included in the judgment text, but were considered to be training data. And next, the hard case. It has been pointed out that AI is not good at dealing with hard cases where decisions need to be made under conditions that have never occurred before, due to its nature of learning from past examples. And last, the prohibition of use of private knowledge. So in Japan, Judges are supposed to make decisions based on the evidence submitted to the court by the parties, and it is prohibited for them to use facts or rules of some that they happen to know personally in their judgments. Similar restriction can be seen in continental law countries such as Germany, which is the mother of law of the Japanese Civil Procedure Code, and in common laws countries such as the United Kingdom and the United States. And this could be a problem when extracting knowledge from generative AI. So let us back to the possible applications. The challenges with first and second is whether it is possible to create an AI with the ability to make inference about logical consistency. For this, it is thought that information such as past case record will be necessary. Even the research on legal judgment prediction models that is being actively conducted worldwide, many studies train on the court judgment data only, and it is likely more research will be required to expand the training data. For third and fourth applications, it is necessary to consider how to deal with the risks, such as hallucinations and biases. A technique called retrieval augmented generation, in short RAG, has been devised, which provides prompts with the knowledge that you want to refer to when generating responses from large language models. In particular, ninth, the prohibition of private knowledge use is considered to be a major legal problem, a governance issue. The following section is devoted to a more detailed discussion regarding with the prohibition of the private knowledge.
So, go to the prohibition of the use of private knowledge. Litigation proceeding in Japan also adopt the basic premise of adversarial system, and the parties are responsible for submitting court documents such as claims and evidence, and the judge will discover the truth and make a decision from a fair and impartial standpoint based on these. On the other hand, since it is assumed that judges know the law, it is essential for them to carry out their duty by collecting and investigating information about the law, which is updated on a daily basis. However, the scope of this includes legal practices such as law and precedent, as well as socially and scientifically established knowledge that should be applied to the case in question. Furthermore, with the recent development of digital tools that make it easy to conduct sophisticated research, the tension between the two main premises have increased. This intensification is the reason why we are now re-examining the basis and scope of the prohibition on judges using their private knowledge. To understand this norm correctly, we have to go back to the starting point. There are parameters on the debate of the use of private knowledge. First is the impartiality and integrity of the judge. That is, the final decision rests with the judge. Judge is responsible for determining the fact and does not uncritically accept expert opinions. The second parameter is fairness of the proceedings. That is, transparency of the proceeding for the party is very important. Third parameter, truth findings is his duty. Judges are to find the truth of the case. Fourth parameter, the guarantee of due process for the parties, which is also important. Fifth parameter, the need for judicial economy to ensure efficient proceedings. And last one, sixth parameter, violation of the prohibition of the use of private knowledge infringe on the right to examination and dispute in the court proceeding, guarantee to the parties under the Constitution. Such right is derived from the right to access to justice, which is constituted in the Article 32 of our Constitution. As mentioned above, the norm has to be understood as a principle that judges should not conduct a distorted decision under the influence of fact or knowledge obtained outside court that the parties are unaware of. The Code of Civil Procedure also stipulates that a judge should not be disqualified from performing his or her duties if he or she becomes witness or expert witness in a case he or she is in charge of. And from a perspective of ensuring the fairness of the judgment, the use of private knowledge of fact is prohibited. In the process of fact findings, judges use rule of thumb to establish fact from evidence based on the principle of freedom of personal conviction, but the rule of thumb referred to here are divided into general and specialized ones. While the use of private knowledge and investigation is permitted for general ones, and the investigation is considered part of the judge's duties, the use of specialized one is restricted. However, there is also opinion that allow the use of specialized rules of thumb when the due process for party is guaranteed. In addition, in order to supplement the expert knowledge which is necessary but lacking in the litigation proceedings, judges can seek expert opinion from outside, and the expert rules of thumb that are the result of these expert opinions are used as aid to the judge, assist to the judge, and as evidence. In addition, the Japanese civil procedure stipulates that obvious facts can be used without examining the evidence. In general, it is understood that this includes well-known facts and obvious facts to the court. While well-known facts are generally understood as facts that can be easily obtained and verified from reliable sources, and second, facts that are obvious to the court are understood as facts that the court in question has learned about in the course of performing its duties and that are objectively obvious. The boundary becomes even more unclear. In Japan, those facts that is known to a large number of people or is known only in a specific area but can be easily verified from a reliable source can be established without proof, insofar as it does not harm the due process for the parties. When it comes to the aspect of problem interest of this study, the collection and use of expert knowledge that is expected to be used by generative AI, the following write-up is useful. It is not necessary to examine evidence for matters that have been generally accepted by the expert community or that can be confirmed by generally trusted sources, and it is possible to use the judge's private knowledge. The same treatment is also recognized for expert knowledge that become obvious to the court through the accumulation of precedent. However, it is necessary to ensure the party have the right to dispute whether such knowledge applied or not. And for cases that require expert knowledge, consideration must be given to impact on other similar cases. The accumulation of precedent makes expert knowledge obvious fact to the court.
So, we can suppose the design of an application like this used in the court judicial decision making. But we have to answer these questions below according to the former discussions. But in general, the training data for the foundation model is not enough clear, as you can see from the table. There's a potential risk associated with this using only the knowledge contained in the generative AI services or pre-trained large language models that have been distributed, such as lack of guarantees regarding to the fairness and social biases of training data that has been crawled from the internet, and the lack of guarantees regarding the reliability of the information also. In this regard, we can hope that the implementation of lag will make it possible to reduce the risk of hallucination and ensure the reliability of the data by preparing the separate database containing information that is considered reliable or generating sentences that refer to the information. And it is also hoped that the issue of biases can be addressed by taking the verifiable processes that eliminate the opacity of the training data and training methods of the underlying models to a certain extent. However, it is so that the governance of this construction and the use of this RAG database needs to be consistent with the former discussion on the use of private knowledge and obvious knowledge to the code. Even if we assume that the knowledge used to train the foundation model is widely and easily available, including information from publicly available corpus and information crawled from the internet, at a certain point of time, it is inevitable that the correctness of the content to be verified and expert knowledge, it should be reviewed by the expert community. So by building the database that contains expert knowledge that has been verified as accurate and obvious facts to the code through many proceedings, and using it as a database for such knowledge in lag, it will be possible to search for and explain expert knowledge regarding to the circumstances and conditions of the case through generative AI quickly to support judges and even parties in process such as fact findings and examination of allegation that require expert testimony. However, in order to ensure the parties to have opportunities to dispute, it is considered necessary to make an implementation of RAG database and the knowledge stored within publicly available, accessible, and provide opportunities for a verification. Furthermore, we cannot eliminate hallucination and bias risk completely just by using RAG design. So the implement process and narrative in the database should be opened to the public. So as a conclusion, we would like to propose a governance of legal RAG database, making publicly accessible as a kind of public good that can be achieved these requirements. So thank you for watching.